So Ms. Winkles, are you still there? Okay. It'll be a few minutes and then we'll get going on yours. I think he's, what's that?
He's supposed to be in person.
I thought he was, so his attorney just went, over to, is dealing with a Wakayakum case first, and then we'll be right back. So as soon as she's back, I'll be able to find out.
Thank you.
Thank you. Alrighty, any other agreed continuances? Agreed continuances.
Your Honor, I don't know how you want to deal with number 7, Cooking Davino.
That's 3.
3. That what I thought was an agreed continuance. We just got the information from Ms. Turnbull late yesterday afternoon. It was essentially a recommendation without the findings of the report. And again, I understand Ms. Turnbull's been ill. This was scheduled for a review today of the interim findings as well as a presentation. Happy to go forward on the presentation, but given the circumstances and a lot of what's transpired over the past, several months now that you heard in detail at the hearing a couple of weeks ago, I thought we were sending over the substantive portion of this hearing today, which was the GAL review, but after the email received late yesterday afternoon, I'm not sure really what the direction of this is today.
We have Ms. Baldwin, we have Mr. Sandy, we have Ms. Turnbull. Ms. Baldwin.
So in this matter, we are on for presentation and no reason for that not to go forward this morning. Additionally, the court set the matter on for today. There's an issue regarding the children's school as well as the importance of having an interim report because there's some significant safety issues with even sort of the interim situation that the court set up, and the guardian ad litem addressed those and the safety issues and how to sort of safeguard the child during the remainder of the guardian ad litem's investigation. I think it's important that we address those safety issues, even if we come back later for additional review. Ensuring a child's safety should be a top priority, and I think that we shouldn't then just set that aside and move forward.
Let me hear from the guardian ad litem, Ms. Turnbull.
Yeah, good morning, Your Honor. So my recommendations at this point in time are that Kyson remain at Butler Acres for the school year, and that he be pulled out of the after school program. I don't believe that the supervision in the after school program is sufficient, and that's not a safe place for him to be right now, and given in light of what's going on. And then he has, I have given a recommendation for the family to start counseling with Charlotte Rosen. She has agreed to take the child on as a client, and they've been given that contact information. So the parents have mutually agreed to this recommendation, and so he should be starting that anytime now, hopefully moving forward. And then my concern is that the court ordered no contact with Landon, who is mother's half brother, and mother is living in a trailer on her mother's property where Landon is also living. And so the proximity there is making that no contact difficult. And so my recommendation was to have the boys live with father and have daytime visits with mother on Fridays, Saturdays, and Sundays until mother moves her residence. And mother emailed me this morning that she could move in with her grandmother essentially immediately. And would that be okay? I'm not familiar with the grandmother's location, but I'm open to discussing it. I think that as long as there's a distance and they're not in contact with Landon until we can understand more clearly what's happening, then that could potentially be a solution. We just need to take seriously the concerns about what's happening with Kyson and make sure we're covering all our bases to make sure that he's safe.
So I want to understand one thing real quick, and then Mr. Sandy, you can respond. Ultimately, my intent is to address some of this. I'm not necessarily going to address everything. But school's starting, and so I don't want to wait 2 weeks and then, that kind of thing. And so to me, that's a big issue. And my understanding is he goes to Butler Acres now, correct?
Both kids do. There's Jameson, who's the older brother. There's Kyson, who's the younger one. They're both have been at Butler Acres for some time, correct?
Okay. All right, so my intent was to go ahead and just have him remain at Butler Acres. And then if there's a need to do something different later, then that can happen. But at least for now, that would be my intent, is that he remain at Butler Acres. And the after-school program, any response on that? I agree with the concern, so.
And I think everybody's concerned about the same thing. Me personally, no, I think that makes sense. Cannot confirm that with my client. We've emailed back and forth. Again, given the nature when we received everything, I'm coming here a little bit less prepared than I typically am just because of the timing of that. So I would need confirmation from my client, which I can get. I think given the circumstances now, if we do set this again in 2 weeks so that you can get full argument on what the issues are and then more substance from the GAL, I could probably address it more fully at that time. But for now, I think that's probably okay as an interim Band-Aid to this.
Okay. Any objection to that idea?
On the after-school program, no, my client agrees that certainly for the interim, that's appropriate to remove any potential risks from the child.
All right, so I will go ahead and adopt that for now. That he will discontinue the after-school program. In regard to, I'd like to get him in counseling as soon as possible, but I didn't know if you had
I
any.
think we are agreed with that. I think they've already taken the steps to do that, and I think that's certainly appropriate.
Okay, any objections to that?
No objection, but I am asking for a specific order that neither parent can now remove him from Charlotte Roseman. The problem is now we've bounced from counselor to counselor to counselor to counselor. And every time one parent gets a word they don't like, then they remove the agreed decision-making. We now need to stay with the counselor that we have. So there just needs to be an affirmative order that now we're with Charlotte and that doesn't change.
Okay, no objection to that.
No, I think that makes sense.
All right, so that language can be added in there. And then the final recommendation had to do with the issue in regard to no contact with Landon. I don't know what mom feels like.
This is the issue that I think we've had from the onset. This is a case where there's been no findings. This is one where we have absolutely zero idea what's happening to this child or in what capacity. Dad has unfortunately kind of piled on this, again, teenage child, making assumptions that have not been founded. We do not believe it is Landon. In all honesty, I'm somewhat leery to even say this child's name because, again, he is a teenager and we have no findings that he is a threat or has done really anything in this capacity. So that's first and foremost. I certainly understand where Ms. Turnbull is coming from. Nobody wants these kids to be violated. However, there's a complete diametric disagreement onto what the source of this is. We certainly don't believe it's Landon. We think it's some other third party. We've given you that information. You heard that at length a couple of weeks ago. I think it's pretty extreme to say, okay, mom, you need to move and we're going to take custody of the kids. We're going to place them with dad. When dad, in fact, again, going back to prior arguments, is the one who is pawning these kids off without notice to my client on these various third parties. We gave you information related to that at the last hearing and just assume, okay, well, that's one potential threat eliminated. So therefore it's going to solve the problem. Again, I think that's extremely naive to take that approach. That's why I want to see the substance and the basis of Ms. Turnbull's findings, because I think the findings will kind of dictate where we go on the recommendation and eventual order with this. I think that's why Ms. Rosen is important in this. I think she can help get clear a lot of this up. I would certainly agree that we should remove all hazards to these kids. Unfortunately, where we're at right now, there are a lot of potential sources of hazards to them. So to pinpoint one teenage child where there was an issue several years ago, which again was I think relatively clearly explained away at the last hearing, I think is naive. So I don't like that recommendation. I don't think it necessarily applies to this case. I don't think it solves the problem. And you're giving dad more time with these kids when very likely, or potentially at least, dad is the one who exposed at least Kyson to these issues in other third parties' homes. So again, we're putting more onus on dad when we just don't know what the source and the root of this is. My client did, to Ms. Turnbull's point, indicate to me last night in an email at about 10:45 that she is exploring other options, that she can move to grandma's house. And again, my response to her first thing this morning was, give me more information on grandma. Give me more information on what that looks like so I can present that to the court. She did send me 2 emails, again, that I was not able to dissect immediately before coming over here today. So again, we're dealing on very limited information. I think it is somewhat haphazard. if we just say, okay, well, the kids can go with dad until mom can find a new place, because again, that's potentially exposing them to risk. So I think we stay kind of with the existing order, which is kids don't have any contact with Landon. I think that was clear at the last hearing. My client has done everything in her powers to comply with that. To the best of my knowledge, there hasn't been any issues since. So I think that's the best we can do. Again, seeing where this goes over the course of the next couple of weeks up until the time school starts. So I wouldn't make any changes to that. I certainly think pulling back from mom's residential at the time with both kids is not in their best interest. And again, I think it's extremely premature to jump to the conclusion that, well, again, this teenage child might be the one who might be the one who is somehow victimizing these boys, when the record just doesn't indicate that. So that's my position on that. So I am pretty strong on not adopting the GAL's recommendation without something to substantiate that this teenage child is a threat to these kids. And there just hasn't been anything outside of the speculation and assumptions made by dad that there is. So that's my point on that. I do think that the kids having time taken away from mom, again, who the GAL has found in prior reports to be the primary parent who's done a lot of their day-to-day care, who has done a lot of the primary care functions over the entire course of their life, is extremely detrimental to them, especially on the eve of school starting again under these circumstances. So I do have a definitive issue with that. Certainly don't think that is in either child's best interest. I would ask that the remaining order stand as we're likely to present and discuss here momentarily.
Baldwin.
The record repeatedly confirms that Landon is an issue. We have verified reports from expert third parties. We have the professional Cowlitz County Threat Assessment Team from Educational Service District 112. That report specifically goes through and makes the affirmative recommendation that says these should be taken seriously and says to discontinue all contact with the uncle. That's their recommendation based on the school reports, which are also part of your file, that talk about repeated contacts with Landon and how Landon taught me how to do X sexual act and how Landon said X and Y and how exposed me to X and Y. When you look at the guardian ad litem report, which was filed some time ago, even that report fully acknowledges Landon is the one that exposed these boys to pornography, substantial pornography. The first line of the pornography exposure section says Ms. Cook does not deny the incident, which is exposure to pornography with Landon happened. It goes on and it talks about how specifically one of the stepfathers who was supervising them, the boys were playing video games in Landon's room and Landon was looking at porn on his phone. And then that's how the then younger boys were exposed to that. Similarly, the report talks about how Landon calls Jameson, the older boy, offensive names like beaner and faggot. So this is not a positive influence on these children. This is somebody who is incredibly negative, exposes them to negative things. And we have a family that continues to be in just absolute denial. I appreciate the concept of not wanting to sort of place blame on this teenager, but they've gone to the other side of that fence and refused to protect these younger children. And that's the situation we're in now. These younger children now have been exposed, and that exposure has continued because the protective factors just are not in place in that household. And you see Kyson's behavior ramping up and ramping up and ramping up and getting worse to where now Kyson is a threat. He is the one who is now having the threat assessment because now he is a threat to others. Abused children abuse other children. And that is unfortunately the situation that we are in now. It is imperative that we protect this, both of these young children, but especially Kyson, who is especially vulnerable. The guardian ad litem's recommendation allows for those protective factors. And it's important because, again, we have now a long history of a failure to protect these two children in this household. But if you look at the broader picture, we also have an incredibly disruptive household. We have repeated moves. Mother's moved repeatedly within the last 2 years. She's now living in a trailer and it's now, well, now I'm going to go make another move. But we have to remember the trailer was a recent move. So she moved to the trailer. Now she's moving away from the trailer. So we've had repeated moves within the last year. That's not a stable household.
Yeah, I appreciate
So-
the arguments.
So I'm going to say this to both of you. I heard all the arguments, so I know all the information. I don't need to hear it again. I know what it is. I know what I wanted the guardian ad litem to look into it. So unless there's something more, Ms. Baldwin, that's new,
So it's just simply that the record does in fact show this. The guardian ad litem's recommendation is protective for the children. I think removal from the actual program, as we've ordered, remaining with Ms. Rosen, and I think we should at this point adopt the schedule. I think that that makes the most sense. And the mother's, whatever housing situation she obtains, it should not be an immediate move back. I think that there needs to be a verification that the housing is a rational situation, and not that we're just from the frying pan into the fire with these two children.
Anything further?
Well, and that's the point. And no, I don't have the answers to that.
Okay.
We don't know. But again, I think moving the kids out under those circumstances, if there's alternative housing, which is suitable, I think is somewhat of a grave mistake. Just don't want to see any more disruption to these kids' life.
When do they actually start school?
Wednesday.
August 28th, I believe.
Yeah, that's next
Okay.
Wednesday.
Okay. All right, so, it's very difficult. We don't have a complete set of information to know everything. Yes, there are some major issues and concerns in regard to the uncle, and the court has that. And the court also sees this as an issue with where mom is living. I had ordered no contact, but if she is in a place where that can't be enforced, then that creates an issue for the court and concern for the court. So what the court is going to do is, I do not want a major move, but I am going to place the boys with dad for right now. I'm not ordering mom to necessarily move or do anything. That's up to her. And I'm not putting it conditional. I'm just for this next couple of weeks until we have full information, full argument on it. Dad is not to leave these children with anybody else. No third parties, is to not have the children around any kind of pornography. If that's what he's doing, he's to be mindful of that. And then once we have more information, I'm looking more at this kind of an end of summer. They have time with dad. So I'm not looking at a major move here. So it's just to have them with dad until the case is fully argued at in 2 weeks.
Okay,
Send it over to the 3rd, and you want to,
that's fine.
what do you want to do with the order presentation today?
Does Yarn want to do the presentation, or do you want to just set that over to the 3rd? I'm fine with that.
We're going to set it to the 3rd,
That's
by the way.
And I'll get you updated information from my client, hopefully in the next week or so.
Okay.
Yeah, I can get it over a week out.
Okay, very well.
All
Thank
right,
you.
thank you.
Noel McLean appearing on behalf of the petitioner.
Good morning. I'm appearing on behalf of the respondent, Justin Kaufman.
So we did receive your honor's ruling relative to the order for the presentation. I went ahead and made those changes this morning. I forwarded that to Ms. Baldwin, so hopefully she can sign off and we can submit that ex parte.
Ms. Baldwin, did you receive it?
So I did receive it. So here's what I'll probably do. I appreciate that council edited my document. It's an odd situation to have somebody else edit your own document when the edits are not clear. So what I'll do is I will take your changes. I'll go ahead and make those edits, and then I'll recycle that back to Ms. McLean, and then we can enter that ex parte. So I don't disagree with necessarily the procedure. It's just, if it's my footer, I think that what was drafted and what I'm presenting should be clear. If there were changes made to an order by someone other than myself, I think those should also be clear. When we do those by hand, it's very clear that those have been made. And so when I received it, honestly, this morning, I was looking at it, I was kind of like, oh, I'm not sure where the changes were made. And so I just want to make sure that it's really clear for both of us.
So I'm happy to outline that for council if she needs me to, but I mean, the order is fairly simple.
I don't necessarily disagree. So I think that we should be able to wrap that up very easily, though, and send it in ex parte.
All right, go ahead and make your changes to your order. I appreciate what you've done, Ms. McLean, but I'll go ahead and defer to Ms. Baldwin on her order. And hopefully it gets finalized and submitted for signature.
Sure. And then we're here on my client's request for a protective order relative to the text messages.
And I disagree. There's no order to shorten time. This was served on my office on, I believe, Monday. So that's less than a week of notice. So I certainly have issue with that. I have not had an opportunity to respond given the shortened notice. I don't disagree with trying to hear it on an expedited basis. I know that sometimes Your Honor has availability in your week, not always, but sometimes. If Your Honor is able to hear this later in the week, I'm happy to do that, but I have not had an adequate time to respond, given that there wasn't even an order to shorten time.
Well, counsel and I had agreed through email and reiterated at the deposition on August 9th that this would be heard on today's docket without an order shortening time. So, I mean, I can produce those emails to the court that we would set this for today's docket. And again, I think that's in the transcript. I'm assuming that's in the transcript from the deposition. I haven't received that yet. But as soon as I do, I mean, so if the court wants to set this over, I'm fine with setting it over. My preference would be that it be a week, just because I have family in from out of town this week and I'm already in court 3 days this week.
My preference is Friday, if that's at all possible. I know sometimes there's time on the presentation docket, if that's available, just because we have an arbitration coming up in this case relatively soon. And so I just want the issue resolved one way or the other.
So I really don't have time this week. I have other matters that have been scheduled into my time slot. So that can't happen, unfortunately. So that would leave, it needs to be set over to Tuesday.
Okay, very good.
So,
Tuesday it is.
27th.
yes.
Okay, thank you very much, Your Honor.
Thank you.
That matter's ready. And I do have some preliminary objections when Your Honor's
For
ready.
the record, we have Ms. Baldwin, we have Ms. McLean.
Yes, Your Honor.
Okay. All right, Ms. Baldwin, you said you had some preliminary matters.
Yes. So I do have two objections for the court to consider prior to argument. And those are Ms. McLean attached to her materials, emails between Ms. McLean and myself regarding a potential protective order. I'd argue that these are ER 408 communications. These are offers in compromise. Essentially, it's myself making a how about this, Ms. McLean then sending counter offers and then offers being sent back and forth that are offers and counter offers. These are offers in compromise regarding the proposed protective order. There's never an agreement. Presenting them now as if this was the agreement or look, she agreed to this is improper. And the reason why it's improper and the reason why we don't produce things like this is because it robs from one party the benefit of the bargain. The benefit of the bargain of the original agreement was I would have had those documents in hand. I still don't have those documents in hand. So it's to say, well, she would agree to that. It's like, well, I might have, but I would have gotten the benefit of the bargain, which was documents in hand at the time. So that's why we don't produce them. So they should be barred and the court should not consider them under ER 408. Second,
Let me address that first, Ms. McLean.
I would argue that it shows clearly that there was a meeting of the minds, just the first two communications. One, because I had called counsel's office and left a voicemail. My call was not returned. And because it was time sensitive, I sent her the email outlining that I would be requesting a protective order on behalf of my client, asking that the documents not be disclosed to her client and discussing redactions. And her immediate reply was, yes, she would agree to that. But then after that, the communications were that, no, she didn't agree to that, although clearly there was a meeting of the minds when you take a look at her response where she clearly acknowledges that, yes, she would agree to not disclosing her documentation to her client until I had an opportunity for this protective order to be heard by the court. So that's the starting point. And then it changed from there and the representations were different. So my goal in providing that information is to show that I've tried to make a good faith effort to resolve this issue with counsel before bringing it to the court, that we did have specific communications related to that, and that those communications were again reiterated during the deposition on, what was it, the 9th, August 9th, as it relates to noting this matter up for the 20th relative to my client's request for a protective order specifically related to the text messages.
So Ms. Baldwin, I'm going to grant your motion, and the court doesn't, we go down a really rocky road when we start entering emails. Maybe there's a different way that could be done, but the court's not going to consider them.
and then the second issue is attached to the declaration of Ms. McLean's client. There's a number of hearsay materials. Specifically, Exhibit B is child hearsay. It's text messages of a child. Exhibit C is text messages of Nicole Cathcart. Simply making it a text message doesn't mean it's not hearsay. It's still hearsay. Just the fact that you've made it in the form of a text message doesn't change that. So these are just clearly hearsay communications. They can't be considered. It's very straightforward.
Ms. McLean.
As it relates to that declaration, we were simply providing the prior declaration that had been considered by the court. I don't recall if that specific objection was made at that time, but again, it simply goes to show the information relayed by Mr. Kaufman in supporting his history of bad behavior and my client's concerns relative to whether or not these text messages between her and Mr. Evans are going to be disclosed to Mr. Kaufman.
Ms. Baldwin.
So again, it doesn't change. She doesn't argue that they're not hearsay. The court can't consider hearsay, and especially can't consider child hearsay. So it's not appropriate to just say, well, the argument is throw out the rules of evidence and consider it. The court can't do that. The court just simply can't consider these.
So the court is going to grant the request, not consider those texts. I understand where things are at in general, Ms. McLean. So there's no need for the text.
That's fine. So this is on my client's request for a protective order. As soon as the subpoena was received, I forwarded that information to my client. She immediately expressed concerns relative to the intimate nature of what she anticipated would be shown in the text messages between her and Mr. Evans. And I reached out to counsel relative to entering a protective order or an agreement relative to a protective order in order to avoid this hearing, but acknowledging that I would be noting this matter up for a protective order, whether or not she would agree to it being entered on shortened time without a motion for shortened time. Based on our communications, I understood that that was agreeable. And she also acknowledged that if there were additional information that she wanted to bring before the court, that should be acknowledged on shortened time as well, without motions. Just so the court is aware, we have this matter set for a binding settlement conference before retired Judge Warning on September 12th. And so the expectation is that we're trying to get this completed as quickly as possible so that the information can be, whatever relevant information can be considered by the court. We are asking that the court, and I've provided in camera the clean copy of the 14 pages of text messages and the redacted portion, or the portion that I'm asking to redact on my client's behalf. Those redactions are very limited. There's 14 pages of 559 pages that we're asking to redact. And the redactions specifically are related to intimate photos and discussions between the party as it relates to those photos and the like. We're asking to redact Mr. Evans's driver's license photos, the credit card photos, and his social security number. The claim in the response is that, well, that information can show facts of a committed intimate relationship. I guess first off, I would note that Mr. and Mrs. Kaufman are still married. A committed intimate relationship cannot commence with a married individual. So I would just throw that out for the court's edification. In any event, when you review through those redactions, none of those would support any potential claim of a committed intimate relationship between these parties if my client were not currently married. So my client's concern is, given Mr. Kaufman's history of inappropriate text communications with her, he and his family inappropriately involving the children, even the guardian ad litem commented about the vulgar and inappropriate communications by Mr. Kaufman to my client during exchanges when he's trying to grope her and engage in appropriate communications directly in front of the children. And there are court orders outlining the court's concerns regarding his behavior and essentially providing a bright line that the court was concerned and he's on notice that this is not going to be tolerated. Obviously, these parties want to be and need to be divorced, and my client is extremely concerned that if her communications between herself and Mr. Evans are disclosed to Mr. Kaufman, that this is again going to inflame his behavior, that it's going to cause her harassment and embarrassment from him and his family, as has been done historically, and she does not want that to occur. her greatest fear is that these are going to be disclosed to the children. If they're included in court filings, the children could come back after the fact and review through those. If they're produced through documentation for the binding settlement conference that's disclosed to Mr. Kaufman, again, he could provide those to the children at whatever age they are, now or in the future. And that is extremely concerning to my client, given her relationship, her closely bonded relationship with the children, and her perception of Mr. Kaufman's efforts to try and malign that relationship. I acknowledge that there is an openness presumption, but that openness presumption can be overcome by can be overcome in order to protect significant and fundamental rights. And Ms. Kaufman has an absolute right not to be harassed by Mr. Kaufman, as has been shown has occurred historically. Under the case law that I cited, this would be considered the fruits of raw discovery, and the court certainly has the power and the ability to limit the scope of discovery and the use of its fruits upon a motion for good cause shown. And we've provided that good cause shown given Mr. Kaufman's history. Furthermore, if the court does not allow protective orders, that can cause a chilling effect upon denying parties access to the courts to pursue their just claims if they're not going to be protected against the potential exposure for harassment, embarrassment, and other concerns that are outlined in Civil Rule 26C. The goal is to prevent unintended harm through the use of protective orders. And in weighing the parties' respective rights, my proposed protective order allows Ms. Baldwin access to the records with those redactions that we've asked the court to review and approve, and to have third-party personal identifiers and intimate photos redacted. The financial records that were already produced did have the sealed, were redacted as far as personal identifiers, and even counsel's memo indicates that they are fine with intimate photos and personal identifiers being redacted. But the concern here is moving forward, my client's legitimate concern about Mr. Kaufman having access to these as it relates to her children, and arguably her relationship with Mr. Evans and the children's relationship with Mr. Evans. It's very invasive to ask for these types of text messages in an effort to suggest that my client is committing perjury and is not telling the truth, which we adamantly deny. I would also note that obviously counsel and Mr. Evans have not received the text messages at this juncture, and it is inappropriate for counsel and Mr. Kaufman to claim that I or my client have manipulated text messages. I've provided those clean copies to the court in camera of the ones that I've asked to redact. I am an officer of the court. I am absolutely not going to do something to materially alter text messages or information. That's why I provided in camera to the court both the clean copy and the redacted copy, so Your Honor could make a determination of whether or not my proposed redactions were appropriate and how you wanted to limit those if you felt that that was appropriate. I take my ethical oath very seriously, and the suggestion that that would show up in a declaration before the court when they have absolutely no basis for that claim, quite frankly, is offensive. In regards to the suggestion that I've implied or instructed Mr. Evans relative to any of these documents, again, there's absolutely no basis for that. I have absolutely not done that. I understood, if anything, that he had forwarded documentation to Ms. Baldwin, as he did with regards to the changes or the corrections to his deposition. And I clarified with him after I had received those, and he confirmed that that had been completed. So we are asking that the court grant the protective order. And essentially what the protective order does is it provides for the redactions that we're requesting. It provides that those would be given to Ms. Baldwin with the protective order on the top, that obviously she would be able to review those. We're asking that they not be digitized because it's too easy to violate a protective order if that occurs. We're asking that the court not allow disclosure to Mr. Kaufman, and that those pertinent excerpts from the text messages that counsel deems appropriate for the case at the binding settlement conference would be provided in camera to Judge Warning with disclosure to me as far as what documents she's producing. And then if the court is inclined to allow Mr. Kaufman to review these, we would ask that the court tailor an order that he's only allowed to review them in office with Ms. Baldwin, that he's not allowed to receive a digital or a photo or a paper copy of the same. And that, again, any documentation used for purposes of the binding settlement conference would be provided in camera to the court. We believe that this motion has been brought in good faith. Within a day of receiving the documentation by email, I advised counsel that I was intending to pursue this protective order. We communicated through it about it by email, ultimately by phone, and at the deposition. And there was no opposition noted by counsel about my intention to bring a protective order. So I believe that we are here in good faith and ask the court to grant the order as proposed.
Ms. Baldwin.
Thank you. I don't want there to be any confusion. At no point have I received the text messages, and at no point have they been offered, and there's never been any confusion that I've received them from any party. So there was some sort of statements about maybe Mr. Evans provided them. That's never been a confusion. He only provided them to Ms. McLean's office, who redacted them. It's important to start with the law because that's where we are. We're dealing with the law. And I would argue when you look at their legal briefing, it's really limited. And that's because there really isn't legal support for their arguments. When you look at the sort of sole basis that the court can limit discovery is to protect fundamental rights, things like privilege. If the text messages included text between Ms. McLean's client and Ms. McLean, of course, those would be protected. And that's why we do a privilege log when we do discovery. It's not a, hey, this is something I don't like and I'm not going to provide it. It's a privilege log because it's privileged and it's a fundamental right. And that's why we withhold those things. So this very limited carve out is very limited. It is a guaranteed right, not only for my client, but also for the public, that what we do is open and that it is a public process, and that is critical to the overall integrity of the court. The right to review your own discovery is a constitutional right, and there is no case that says you don't have the right to access your own discovery. Counsel can't cite one because there isn't one. It is instant reversible error to hold that a party cannot review their own discovery in their own case. It's removing them from their case and preventing them from preparing their own case for trial. Even in the most heinous of criminal cases, defendants have the right to review discovery in their cases. It is absolutely bad faith to make this request and ask for this relief. This is well-established law. This is a constitutional right. It is clear and it is unambiguous. Second, there's this request for essentially a blanket protective order, and really it includes a gag order. So it's not only protect these documents, hold them, and it's a blanket. It is not a protect 1, 2, and 3. It's a put a blanket over all of these text messages. And it's also a gag order. It is a he may not talk about them, he may not see them, he may not provide them to anybody else. That's a gag order. And we have to be especially careful when we talk about doing things such as a gag order or a protective order of that nature. These are highly, highly disfavored under the law. And there is just an absolute significant body of case law that says these are only to be done in an exceptionally limited circumstance. And we don't have that here. There has to be specific and articulable harm that is directly connected. It cannot be this tangential connection that counsel is trying to make. Hey, there's a guardian ad litem report that says a third party, grandpa, said something that mom didn't like. That doesn't have anything to do with documents, anything to do with text messages, anything to do with the boyfriend. These are not connected in any way. Hey, well, maybe Mr. will say something bad that we don't like. And here's some text messages from more than 2 years ago. Again, nothing about documents, nothing about discovery, nothing about how discovery was provided to the children. None of that. We don't have any of that. And they still have to go back to almost 3 years ago to be able to make this claim. So they don't have any current evidence whatsoever. They have only text messages from 2022, essentially when this case started. Additionally, this has to be a document by document analysis, essentially page by page in this case, because these are text messages. You can't simply say, hey, cover it all. Again, blanket protective order. That's not what case law supports. It supports that if you're going to order a protective order, it has to be document by document analysis. And they have not done that here. They're simply, again, asking for a blanket protective order, which is not appropriate whatsoever. So in this case, that is fully unsupported by the law and inappropriate. And I would argue simply bad faith. This is limited in scope. When you look at the scope of the request is essentially from exactly the time they started living together through the current date. So Mr. says we started living together in July of 2023. That's Mr. Evans. And that's when the request starts, is July of 2023. So we have a almost exactly scope limited request. So again, we have a scope limited request. They have absolutely not met their burden. This is their burden to meet, and they have not met it. It's important to note that I've not been unreasonable. I understand that there may be some inappropriate photos, and I've said it's fine. I should receive the full documents, and I'm happy to do some redactions of inappropriate photos so that my client doesn't receive inappropriate photos. That's fine and reasonable. And similarly, to remove, frankly, for Mr. Evans's comfort, to remove all but the last 4 of things like DOL numbers and account numbers. But it is important to leave the fact of the transfer of those numbers in, because those, again, show financial alignment between these two people, which is important when we're talking about resources, the availability of resources, the pooling of resources, and the need for spousal support when Mrs. already has somebody who is providing financial aid for her family, and that person is someone that she intends to marry almost immediately. And although Ms. McClain is making this request, she doesn't represent Mr. Evans at all. Mr. Evans has not made that request through this court. So it's a bit odd that we're in this position at all. But those redactions should be made by me, not by counsel. Counsel similarly makes this very inappropriate request that, well, I've received all the documents digitally, but Ms. Baldwin should be able to receive them. We live in a modern era. We use modern software. The idea that, well, Ms. McClain can use that modern software in order to access and digitize those records and be able to search them electronically, but Ms. Baldwin can't. She's got to do it by hand. So again, that's trying to hamstring my office when her office has already received them digitally. So again, this is just sort of one more strike at trying to prevent my office from being prepared to go to effectively a trial within the very, very near future. There are serious concerns in this case when we have a deposition that's scheduled of a non-party. This is a third party who is then subpoenaed to bring documents. That party is then told to submit those documents to Ms. McClain instead of to my office, and then admits that he didn't bring anything with him to the deposition. I gave it all to Ms. McClain. I gave her everything that was requested went to Ms. McClain's office. Well, did you provide it to me? No. Yeah. No. I didn't provide it to your office. This document, that document, this one. Nope. And so there are significant concerns when we're at a deposition and we've asked for those records and they're being provided and redacted by opposing counsel and not provided to my office when there's no protective order in place, there's no agreement in place. That is bad faith, that is interfering with the legal process. That is a substantial concern. And that's why I think the court should order relief here. Lessons are learned, however your honor rules, lessons are learned by everyone here. Either this is acceptable behavior or it's not. You either can interfere with a third party producing documents or not. But if this is acceptable behavior, then everyone will do so. And everyone will say, well, I'll call up Susie Q, who got subpoenaed, and say, hey, produce those to me instead, and don't give them to the lawyer that actually subpoenaed you. And I'm sure most of us would like to be able to edit the documents or redact things or look through them first instead of the lawyer that actually subpoenaed them. And so that causes a significant concern. Interference, absent a court order to do so, is absolutely inappropriate. The motion here is not supported by the law. The court should not grant the relief. The court that Ms. McClain requests, the court should enter our order. I am asking for fees and sanctions. The fees that I'm requesting represent 4 hours of my time, which is appropriate given the efforts here, the legal memo and the arguments today. I am asking for sanction. I'll just note that officers of the court don't interfere with lawful subpoenas.
Ms. McLean?
And this officer of the court has not interfered with a lawful subpoena. I have not discussed or I've not directed Mr. Evans to forward documentation to me. If the court reviews through the court file, you'll see that I did prepare a declaration for Mr. Evans back in 2022. I'm assuming he had my email from those prior communications and that he felt compelled to provide that documentation to me because I am Rachel Kaufman's attorney. So the suggestion by Ms. Baldwin that I contacted him and told him to provide those to me is absolutely false. There's not one shred of evidence to support her claim. And I would not and have not done that. In regards to him independently emailing me those documents, of course I reviewed through them. And of course, in discussion with my client, brought those concerns to Ms. Baldwin's attention that my client was going to be filing a protective order. CR 26C allows for a party to request a protective order. She doesn't have to be the deponent. She has an absolute right to request a protective order. And that's where the balancing act comes in. When you take a look at CR 26C, there's multiple bases for the court to enter a protective order, including harassment, embarrassment, oppressiveness, and the like. My client doesn't want Ms. Baldwin to see her naked body. I understand she's an officer of the court, but my client wants to ensure that those things are protected and redacted. And that's why we're here. And it's certainly within my client's right to come to court and ask the court to enter this protective order, and notice was provided. So we are asking that the court grant the relief that has been requested in our motion.
So based on the files and record and the review of this court in regard to the documents that were submitted to me in camera to review in this matter, the court does find that the law does support a protective order, that the court can limit discovery, and that good cause has been shown to limit such discovery in the manner that the court will be going through here. This is not a fault state. Washington is not a fault state. And at least as to the intimate pictures and the intimate language that is talked about, that would be the only purpose. But otherwise, it is nothing more than to embarrass and to essentially cause trauma to release such information to an opposing party, no matter what kind and type of case we may be looking at. So with that, there is no relevance in what the court is going to identify as not or that can be redacted. Ms. Baldwin, do you have a list of the what was submitted, not the documents themselves, but a list of what was submitted?
I have nothing, Your Honor, nothing at all.
Okay.
I thought that we provided the cover page. Bear with me just 1 minute.
I have
Okay.
your declaration and your client's declaration.
Okay, then that's my error. I apologize. If the court wants me to provide that to Ms. Baldwin, that cover page by email, I can.
I do.
Okay. And then do you want to come back to this?
Yeah, let's come back to it. And
Okay, sorry about that. Thank you.
I'm ready if you want to proceed on Kaufman, Your Honor.
okay. All right. So going down the list that I have for the documents that I had reviewed, and going first to, let me get back to that matter. So Exhibit A, in regard to the photo, that will be redacted. In regard to the intimate language, it will be redacted. There are 3 are actually two things that would be redacted. The language itself is what I'm talking about.
So not the smiley face?
Correct.
Okay. Or whatever face that is.
B, the language and the photo will be redacted.
So not the middle line?
Correct. Exhibit C, it would go from the smiley face and language. The language with this, it's about halfway down.
Right.
That can be redacted. Over on,
The one that starts I always?
yes, that will be redacted. Exhibit D. This is the driver's license. The driver's license will not be redacted, but the license number will be.
Okay. Okay.
And I don't look at this in the same way as I did the other. I just look at this that it's not relevant. And so Ms. Baldwin, I'm just looking at the license number itself, but the license would be provided.
Very good.
Exhibit E, the photo would be redacted. The line that starts with B will be redacted. Exhibit F, going basically a third down.
Mm-hmm.
Well, basically from a third down, all the language down to I'll be there. That can all be redacted.
So consistent with what I've redacted.
Correct. Exhibit G. This is protected language under evidence rule 408, so it's different language.
Can I be heard on that? It's
Yes,
only
go ahead.
it's only protected if it's between counsel and I. If it's an actual offer, if it's one of the parties talking to a third party, that's not protected. It's not privileged. It's not, and ER 408 prevents us from bringing those discussions in front of you. It's not a discovery bar either. So in this case, it's not a bar to discovery, and it's not privileged because it's not discussions with her counsel, I presume. It's discussions between her and Mr. Evans. So that should be discoverable.
Ms. McLean?
And my concern is that obviously he's her intimate partner. And so that is a concern. And my concern is overall, whether or not that would cloud the court's judgment moving forward.
Yeah, I understand that. I also agree with Ms. Baldwin that it's not protected because it's a third party. So I'll give you a couple days if you can provide me something that says differently, but at this point, I agree with Ms. Baldwin.
Okay.
In regard to Exhibit I, the court will.
I think we're on H.
Yeah, I agree.
Did I skip one?
Yes.
Yeah.
Okay. I'll go ahead and redact what's proposed to be redacted as intimate language. Going to Exhibit I, the court will redact what's proposed as intimate language. J. This is a social security number. So Ms. Baldwin, any objections to that?
So my issue is that the fact that they communicated the social security number is important and is something that is a fact that I'd likely use. So I don't have an issue with essentially blackbarring the boxes, but leaving the last four. So it's clear that this is his and it's his number, but not essentially providing you with the whole number. So that's how I would sort of manage that.
There's a box below the number that says that is SSN. And so clearly it would identify the social security number. And I've proposed that language remain in and not be redacted.
And Mr. Evans hasn't made his own request. So it's very odd to me that we're redacting it when Mr. Evans isn't here. He's not making this request.
I was
He
thinking.
did make a request to me when he forwarded those to me. And obviously, as an officer of the court, the intention is to protect individuals' private identifiers, regardless of whether or not they're a party.
So at this point, I'm going to redact the first 5 numbers of the social security number, leave the last 4. The court will go ahead and redact as intimate language. Exhibit L. The court will go ahead and redact as proposed as intimate language. K.
You mean M?
Hold on. M, sorry.
That's okay.
I will go ahead and redact as proposed.
Are we on M as in Mary?
Yes, N as in Nancy.
That's his credit card with his PIN and or not the PIN, but the secret 3-number code, the valid date, and his full credit card number.
Right.
So I'm just asking that you leave the last four, because it can be important to line up account numbers, because we have other account information. If you want to redact the PIN number, I'm fine that the PIN gets redacted if essentially over the black box it's written like PIN. So it's essentially a white box with PIN written in. So it's clear what was redacted, but not the number received. That's fine.
So I will go ahead and grant the redaction of the 3-number PIN and the first 12 numbers of the credit card number, and leave just the last 4.
And we're leaving the expiration date.
And the expiration date. There's no point in that.
Well, other than that would be something that would be asked on a computer if you're paying online. So I guess
I'm saying redacted.
redacted. Okay.
So long as if it says like EXP, like I want the language around it. So it's clear he
Valid
provided.
proof.
Right, just the number. Okay.
Because I can't see these documents, so I'm flying blind. So I'm just asking that it's clear if he gave her the PIN and it doesn't say PIN in front of it, that
It
it's clear
doesn't.
what was.
Yeah, it doesn't. Just the numbers.
Right. So I want it to be clear if we redact out the PIN, that then it says that that's what was redacted. And similar with redacting out the expiration is essentially a bracket that says this is what was redacted. Because
Well, the
it's
language in
important
front of that
he
says
provided-
validate.
Hold on, I'm talking.
Hold
It's
on.
important to know that he gave her the full information, that it isn't just this. He gave her the full information to be able to access and use that essentially that access to this.
It's a photo of the back of his card. It's
No,
the actual-
all she's asking is that it's identified what was redacted on the card.
Sure.
Not the numbers,
Sure.
what it is.
Yeah.
Okay. All right. So those are the items that will be redacted. That was the extent of it. It's fairly limited given the 500 and whatever pages it was, 559 pages. And so that brings me to the issue of whether or not the respondent can remove the items from his attorney's office, because at this point, the court has removed what the court has either seen as information that was intimate, or pictures that were intimate, or information that would not be their personal identifiers that would not be appropriate to release, are all being redacted. So I'm not sure where there's any difference in any other discovery that a client might have. I don't know if you send the discovery with the client or not, but I guess that's where I'm at this point, is what's the point of that limitation?
Well, I guess my concern is, I mean, obviously there's 559 pages of additional discussions and whatnot. And I guess if anything, if the court's going to allow him to have access, then we would ask that there be some order that provides that he's not to disclose the information to third parties or the children.
Ms. Baldwin?
So clients have a right to their discovery. If I withdrew, do I keep it and he's not allowed to have it? So again, we get into a very odd situation that it doesn't make sense, and because it never made sense. So he has an absolute right to his discovery. And especially once, and we always agree to remove the intimate photos. That's never been an issue. As far as my client's fine with an order saying, don't talk to the kids, that's never been an issue. But you may not talk to anyone. That's a gag order. The requirements for a gag order are extremely high and constitutional in how they originate. We're nowhere near that. Counsel can't even approach that burden. So she just does not have that, has not met that. They cannot have that relief. It's not appropriate.
Well, we've already provided evidence, and there's court orders relative to the grandfather inappropriately talking to the children, such that it came to the guardian ad litem's attention. And the court entered orders that provided for Mr. Kaufman's behavior. So again, my client's concern is that this is simply going to inflame him. If you could look back to his text messages to my client from 2022, where he alleged that my client was engaged in a relationship with Mr. Evans at that time, you can see the vulgar names that he called both my client and Mr. Evans. And again, my client is concerned that he might use these in some manner in order to defame her and Mr. Evans to the children. And it's certainly within the court's purview to be able to limit those third-party disclosures. If he gets another attorney, then he provides those to his new attorney.
And again, it does not meet the constitutional bar. The children are one issue of this case, because the court does have jurisdiction over them. But third parties, absolutely not. And the court has to be very careful. The grandfather was very early in the case when the allegations are going back and forth, and there's lots of hearsay that was absolutely denied. And ultimately, we don't have that in the final parenting plan. So these are concerns that over the course of the case didn't end up holding any weight.
Okay. So in regard to the discovery, it's going to be treated as any other discovery, except that the parties are not to in any way publish or share any of the information via any social media or with the children or third parties, except for the purposes of preparing the case.
Right.
There's no point, and that's both parties.
Sure. Presentation on that. And I guess and I'm assuming that the protective order remains with the documentation, since you've granted that.
I'm sorry?
The protective order remains with the documentation.
Correct.
And so does the court, I guess, obviously I want to get this to counsel as soon as possible, but counsel and I historically have difficulties on coming to terms of an order. So how do you want us to handle presentation so that I can get documentation to her?
I have it there is no reason why 500 plus of these documents have not been provided to me. Those should be provided today. There's absolutely no excuse. So I'm asking that those be provided today. The documents, the 14 single pages that need redaction should be provided no later than Wednesday. Your orders are very clear. As far as an order, again, we're pretty short on time. If you have time this Friday for a presentation, that would be my preference. I want to be clear that you're not, other than what you have directly ordered, that is the extent of your order. I have concerns with, again, and these should be provided in the, again, I don't want limits on digitizing. Ms. McLean has them digitally. I should be able to have them digitally. My client should be able to have them digitally. That's how, frankly, we do business. And so things like that, I don't want extra things being snuck into the order. So your order should be your order and no more than that.
So here's what I would suggest that you do. One, I'm going to set it over to next Tuesday. I never have enough time on a Friday morning in the 15-minute slot to actually accomplish much. So I'm going to set it over to next Tuesday for presentation. Give me your orders, give me your objections. I'll do what I've done before, which is just let you know. But meanwhile, I would agree with Ms. Baldwin. Any of the discovery that I have not identified today to be redacted should be provided to Ms. Baldwin's office today. And then the other pages can be redacted and provided as soon as possible by no later than Friday.
So am I putting a cover page on it that says it's subject to protective order being entered by the court?
So I'm assuming, yeah, well, it's only those limited pages. So.
Well, you've indicated that the parties are not to.
All right. Yeah, just put a cover page on it.
Okay. All right.
Your oral order is still valid. So just because it's oral doesn't make it not valid. And then I'm asking that the court sort of made this qualifier on one of the orders regarding, Your Honor said, produce it. And then you said, well, I'll give Ms. McLean a couple days if you can produce something to me. I'd ask that she produce anything that she has or any pitch that she has to the court no later than Wednesday. And I just don't think that we should leave that issue for a long period of time.
I'm fine with that.
Okay. All right.
And my intention
that I was given in camera, I'm going to, I'm not sure how I'm going to have the clerk do it, but I need to be able to have it in the file. It will not be public, but
you need an order to seal.
I do need an order to seal.
Do you want me to send that to you, or is the court?
If you would.
Okay.
Give me an order to seal.
Okay. And I'd have to ask the clerk, do I need to send a check over with that? And so how much?
I would contact Ms. Baker. She was in here earlier, but she
okay. Okay. Thank you.
Thank you. That yesterday to the parties. So anything for today?
I made changes to the orders and emailed those to Ms. Baldwin yesterday. Assuming she emails me a signature page today, we'll get that over ex parte.
Okay. And I've seen Your Honor's email and opposing counsel's, and I'll review both. And I assume we'll be sending that over for a signature likely later today.
Okay. All right. Sounds good. Thank you. Ms. Winkles, are you there?
Yes, Your Honor, I'm here.
Okay. Where is your client at?
My client should be in the courtroom.
He is not. And I have the interpreter.
Okay. He told us he was going to be there this morning. If Your Honor can call this back after the next one, we'll give him a call and see where he's at and make sure that he's there and not on the video right now waiting for, I'm not sure why he would be, but we did inform him to go to the courthouse today.
Okay. Just make sure that he understands he needs, if he's not here, that he must immediately show up, courtroom 3.
Okay.
And the interpreter's here, and I expect him to be here when he's told to be here.
Okay. We will let him know immediately.
And I'll check the other courtrooms too.
Thank you.
He's sitting somewhere.
And Your Honor, he's completely 100% deaf, but he is a medium height Black man. And he's between the ages of 30 and 45. I don't know if that helps, but he is he's completely deaf. So probably calling his name's not going to work in this case.
I had
but
the
we're going to have
interpreter
somebody
here.
go look for him in the hallway.
Yeah, the interpreter is looking for him.
Good morning, Your Honor. Kelsey Demeter for Ms. Fillion.
Kurt Ignacio on behalf of Keegan and Haan.
So counsel, go ahead.
Well, Your Honor, this is my client's, motion and petition to enforce the Idaho decree. And we have filed that and Ms. Fillion has put a response on it. Yeah, I didn't see a notice of appearance by her attorney in that action. Maybe I missed it, but she's filed a response. In the interim, you've ordered visitation to occur. My client's got a couple of just one-day visits. with his daughter. My client wants to enforce, this is my client's petition for to register the Idaho judgment and obtain a order of contempt, because Miss Fillions is just not going to allow my client to have residential time with his daughter. She's just not, but you ordered it and he's gotten the visitation. She's filed separately this protection order matter, and we've objected to that. And there's no basis in the protection order to affect the relationship of my client with his child, Parker. So we're asking that the court order Miss Fillion to comply with the order, the decree. We registered it, that she's filed no objection. They filed no motion or petition to modify it. It is a valid order now here in Cowlitz County, and we would like it enforced. If she has some kind of objections to that, they need to file something. All they've done is file a response saying that my client has criminal charges pending and various other things, but you know, those are, you know, he's not guilty until you know, there's some kind of proof, and there's no allegations that anyway affects his relationship with his daughter. He has a close, loving, bonded relationship with his daughter that's being interfered with by Miss Fillion needlessly. She just doesn't want him to have any residential time. So they have complied with your order. He's gotten a couple of day visits. We want to, they haven't objected otherwise to the Idaho order. We want to enforce that. Now that order calls for visits to be on a 4-3-4 schedule, which would increase the contact between these parties and increase the number of exchanges by third parties. You'd ordered third parties to do the exchanges, and they've complied with that. So my client is asking to go for week on, week off. That eliminates, you know, 4 of the contacts between them in any given week. So a week on, week off schedule. He's had significant time with his daughter up until she decided that she was going to not comply with the order. So those are our requests today, that we go back either to the order 4-3, and that Miss Fillion be instructed that she cannot just decide on her own that she's not going to comply with the court's orders, and that's a contempt. Those are our requests, Your Honor.
Demeter?
Yes, thank you, Your Honor. So it's completely false that Ms. Fillion decided on her own that she wasn't going to comply with court orders. She obtained an immediate restraining order that restricted the time of the father with the child. She was under no obligation to then facilitate any residential time. Additionally, it's completely false to say that she has not filed anything to change the parenting order. She filed a petition to change the parenting plan. She is asking that the court continue the immediate restraining order. The charges and allegations that are against the father are serious allegations. I understand Mr. Agnostu's argument that he's not guilty until proven so. However, during the time that the father was in prison, the allegations against him were so disturbing to the child that the child started counseling. These allegations have severely...
contained in any declaration. As far as I'm not aware of any declaration that raised that issue.
So I also need to understand where did you file a petition?
Right.
I understand there's a restraining order.
The petition to change the parenting plan was filed in Cowlitz County.
Under what cause number?
And it's the same as Mr. Agnostu's. I apologize. It is 24-3-238.
Okay, so let's see, in the 23808, that is the one that is the registration of the Idaho order.
Right.
That's the one that I don't see any petition that was filed in that.
I don't either, Your Honor.
And I'm just looking, and I apologize, my Odyssey is being a little slow, but I'm looking at the petition right now.
In the 238 matter?
Yes, Your Honor.
Okay, you're saying you're looking at it,
Well,
what,
I'm looking at the copy that my staff emailed to me, and I'm just asking them why, if they may know why that's not showing.
yeah, I don't have any notice of appearance. I don't have any petition that's been filed. I have nothing in that matter. I can't say if there's nothing from your client in this without going through each thing, but I don't see anything in the 238.
Okay, I'm just waiting for the response, but if I, should I keep going, Your Honor?
Well,
And excuse me, 23-3.
okay.
That's the protection order, isn't it?
So there's a petition to change a parenting plan or other custody order. And did you register the, I see a certified judgment, but did you register it in Cowlitz County?
The other party registered theirs in Cowlitz County.
In the other case?
We were told by the clerks that these matters would be combined once.
They can't be. We've already looked at it. They cannot be combined because of the types of cases I've asked a couple of times, because that would simplify matters. So in the 224, I do see a petition to change parenting plan, and that's where the restraining order was obtained. So that's, that's the issues. We're crossing over between these two cases that Mr. Anagnostou has the 238, and unfortunately, that's where the case is registered. It's in the 238, and I'm not sure. Maybe it doesn't. Maybe once it's registered, but then to modify, there's no registered document to modify. Yes, there's a certified copy, but it's not the registered copy.
And again, when we were filing, it was, and I understand the clerk told you something separate, but we were told we did not need a separate registration.
So that's something I'll have to look into. I honestly don't know the answer. So, but go ahead.
Okay, thank you. And so, Your Honor, Ms. Fillion has asked to change the parenting plan. This is not the parenting plan. Neither parties were following the parenting plan. Neither parties lived in Battleground anymore. There were issues in that parenting plan that were what school the child would go to. The child can't go to school in Battleground. The exchange points, none of those issues made sense in that parenting plan anymore, which is why she did file the modification. Now, the restraining order was filed for after the father was released from jail in the incident that took place at Ms. Fillion's home, where he became incredibly erratic. He was yelling, he was screaming. The police had to be called. The police report is included with our immediate restraining order. All of these things are reasons why Ms. Fillion is asking that the immediate restraining order remain in place, a guardian ad litem be appointed, but that there only be the supervised visits with the father. The child has raised concerns and is scared about the time that she spends with the father.
Child hearsay.
Your Honor, Mr.
I'm sorry, I couldn't hear you, Mr.
Interrupt you.
Anagnostou.
I'm sorry, I'm objecting to child hearsay being brought into this matter. I mean, there's a prohibition against child hearsay in these matters, and I don't recall that being in a declaration that the child is saying she's afraid of my client.
Your Honor, I said the child has raised concerns. I did not say any specific statement that the child has, and it's the reason why the mother brought the immediate restraining order. Those are important for the court to know and for the court to decide whether or not they're going to appoint a guardian ad litem if there are legitimate reasons for concerns.
So I understand the child hearsay at the same time, and I'm not hearing specific statements, but the concerns. So I'll overrule the objections. Go ahead.
Thank you. So the mother did follow the court's orders. There were the visits, and the father, his mother, attended the visits. My client's mother supervised those visits. He had both of those. Those went okay. But today our request is that this immediate restraining order remain in place. The charges are still pending against the father that brought rise to this, that a guardian ad litem is appointed, and that we move forward with the modification of the parenting plan to better reflect, one, where the parties live, where the child attends school, and what is the appropriate parenting time for this, for Parker.
I'm going to stop you for just a minute. I'm sorry, I can't remember your last name again. I believe this is the gentleman
Yes.
here. Can you just let him know it'll be a few minutes? All right, go ahead.
That was all, Your Honor.
Okay. Mr. Anagnostou?
Just briefly, the allegations are that Miss Fillion does not like my client. Okay. This is with regards to my client's relationship with his daughter. He doesn't want to have contact with Miss Fillion. We don't have any problem with not having any contact with Miss Fillion. He wants to see his daughter. He needs to see his daughter. He was on a schedule, and we disagree that they weren't compliant with the order. There were periods of time when my client would get his daughter for 3-4 days at a time, up to a week at a time. He wants to see his daughter. He needs to see his daughter. We don't want to have a relationship with Miss Fillion. He's denying the allegations, and he has a legal counsel with regards to these charges, and that's going through the process. But in the meantime, he needs to have unsupervised regular contact with his daughter for extended periods of time, so that he's not having contact with Miss Fillion. He doesn't want to have contact with Miss Fillion.
Here's what I'm going to do. The court does have significant concerns in regard to safety of the child. It is a child, and it's a child that needs to be protected. Whether the protection order is necessary or not, that it remains to be seen. At this time, I am going to leave the restraining order. I'm assuming your dad. I don't mean to just look here. The restraining order will remain in place at this time. The supervised visits with dad will remain in place at this time. What I want to do is get a interim guardian ad litem to investigate this. The court feels like there just isn't sufficient information to necessarily make a full decision on everything at this point, and really wants that input from the guardian ad litem to make a better decision as to what's in the best interest of this child. So with that, I need to know the next three.
Next three names are Amy Turnbull, Karen Lawrence, and Twyla Corey.
Ms. Demeter, I don't know if you want to strike any of those.
I did not hear the last name. If you could just repeat that one, please.
Twyla Corey.
Twyla Corey.
I have no experience with her, Your Honor. I have no strikes.
Okay. Mr. Anagnostou?
I would strike Miss Lawrence.
Okay.
All
right, so Amy Turnbull will be the guardian ad litem. Ms. Turnbull, are you still there?
Yes, Your Honor, I'm still here.
All right. So I'm looking for an interim in this. Is that going to be okay for you?
I will make it happen.
Okay. All right. So counsel, if you can get me an order appointing as soon as possible so I can get Ms. Turnbull going on this. Her information is online on the court website. So the parents need to make contact with Ms. Turnbull. Ms. Turnbull, do you want to provide your contact information in the chat?
Sure.
Okay.
I'll do that.
All right, so she'll provide that. So make contact with your attorney and you can get that contact. And then what I'm looking at least at this time, is the supervised visits with dad. Who's been Mr. Anagnostou, who's been supervising?
It is Miss Fillion's relative. I'm not sure exactly who it is. My client's mother is available, and we were going to ask that of you today, if we could expand visits and have my client's mother be the supervisor.
And Your Honor, we have the same concern as we had last time. We do not believe that his client's mother is appropriate. We don't believe that she would not step in if something were to happen.
So what has had to happen, because my client lives in the Portland area, is he comes up and they meet at some place in Vancouver, and he gets to see his daughter for a few hours. It's just not, he wants to see his daughter.
Okay. All right, so here's what I'm reminding Mr. Anagnostou, how often is he seeing the child now?
You had ordered 2 visits from the last hearing, so he got 2 visits.
Okay, all right. So, and is your client working?
Yes.
Yeah, he's in court.
He just answered yes.
Yeah.
He's
Okay.
here in the courtroom. I don't know if you know that.
I knew that, but I didn't know the answer to your question.
Yeah, okay. So what I'm looking at is like 2 visits per week.
Your Honor, with school starting, that might be a little difficult due to the distance.
Well, I want to see my daughter.
Stop.
You gotta,
So what I would do is 1 during the week and 1 on the weekend.
Okay.
And what I want to do on the weekend is that's a 3-hour time. During the week, it's a 2-hour time. And I am going to go ahead and let mom do the weekend supervision. His mom.
right.
Understood, yes.
And then during the week, then that would be the family member. And that would be for 2 hours.
And the meeting place will continue to be the Vancouver Mall, which is about halfway between the parties.
Yeah, I think there's a number of things in there that they can do.
Right.
So we're at August 20th. So Ms. Turnbull, September 17, do you think you can have something by then?
Okay.
Set. I can make the 17th or the 24th.
Let's do the 24th.
Your Honor,
Okay.
I apologize, Your Honor. I am in mediation on the 24th.
Okay, the 17th.
Okay. September 17th. So Ms. Turnbull, if you have been listening, there are 2 cause numbers.
Okay.
What I'm looking to focus on at this point is the 224 one. That's where the petition to modify and the restraining order are located.
Okay.
The
Okay.
other is a registration of the orders. So I'm looking for folks to focus on that 224. And meanwhile, I'll try to look into the issue of once it's registered, if it's registered in one case number, does that take a global perspective? I'm not sure. So,
Okay.
Okay.
Will do.
all right. All right, that's it for today.
Thank you, Your Honor.
Thank you, Your Honor.
We have Ms. Winkles online. We have her client present in the courtroom with the interpreter. Do we have Kelly? I'm not sure how to say this last name. Makupe? Okay. Do we have Kelly Makupe? That's you? Come on up. All right, I will turn this over to Ms. Winkles.
Yes, Your Honor. It appears from Ms. Makupe's declaration that we're almost in agreement here. And she can kind of testify to that, but she doesn't appear to have any problem with my client's parenting. She acknowledges that they were co-parenting. My client also acknowledges that 15 years ago, he was not the man that he is today. He was a drug abuser. He does have a child abuse charge. He went through significant therapy, training, classes, and essentially has completely reinvented himself. He's worked for Amazon for 10 years and has random UAs and random drug tests, which he passes all of them. He was married. He is now divorced. He works a lot, and the only time he is available is on the weekends. It doesn't appear that that's an issue that we have from given what I've read from her declaration, that he should have weekends from Friday to Sunday. And the time of that is really up to your honor, but my client does work until 5 p.m. So anything after that is when he would be available. His job is not flexible. The issue, it appears, would be whether or not my client can take the child on his extended trips or his extended holiday or summer vacation back east to visit his family. My client has other children who are now grown, and he would like to introduce his daughter, the 9-year-old in this case, to her half siblings. They all live on the East Coast. My client's entire family lives on the East Coast. Given the number of family members that he has over there, it would be impossible for them all to come over here. So he would like to take his daughter over there. The mother states no, and she states safety concerns. The reason this doesn't flow is if my client is safe here with the child for a weekend and safe for having 50-50 custody, which he had until 2018 when his hours changed, then he should be safe no matter what location this child is in. The child is 9 years old, capable of using a phone, can call mom, can speak to mom every night if that is what mom wants, to make sure that the child is safe. We have video these days. We have FaceTime. We have Android, Google Video. We have all kinds of different apps where mom can talk to the child on a daily basis. Dad can give the address of where the child's going to be, staying on the East Coast. But it sounds like that's really what the issue is. Mom acknowledges co-parenting. We'd like that to continue. We'd like joint decision making. Really just your standard parenting plan with somebody who works an inflexible job. If mom is not okay with every weekend, dad should get 3 weekends a month, given that they did have this 50-50 plan. Mom has her own past history. Dad has this history of drug abuse. Dad has a history of child abuse 15 years ago, has had nothing in over a decade. Mom, likewise, has really reinvented herself. She's a CNA, has a good job, is doing well. Mom has a history of being with less than desirable partners. Mom's history comes from the men she chooses or chose, including a sex offender, somebody who kidnapped her to Mexico, things like that. But it sounds like both of these people have really changed their lives, and they've really completely overhauled everything about themselves. So we should acknowledge that and kind of make the parenting plan that looks at today and not at the past. And so that's what we'd ask, that our parenting plan be entered, and that we don't put any restrictions on dad taking this child on a holiday to visit his family. He obviously can't go on a weekend. It's not enough time, but come Christmas or Thanksgiving, the child should have her extended family, not just one set of family, but have her entire family. And there are quite a lot of them out on the East Coast. And that's what we're asking today.
Ma'am, you heard what Ms. Winkles had to say. Yeah, if you could pull that mic right in front of you.
Just, you can see me, okay. Some of the statements that he said, like a sex offender, I don't know who that would be. I don't know where he got that information. I don't understand.
So let me ask you this. It sounds like you're in agreement with the proposed parenting plan. Is that correct? Except for the out-of-state part?
What's been working best for, I can have like a 1 day of the weekend, and what's been working best for us is from Saturday to Monday. And he drops her off at school on Mondays. Yeah, and then the reason why for the out-of-state, his family's wonderful and stuff like that. That's not a problem, is that when like traveling and stuff like that, since it's so far away, I've requested like an AirTag or a phone or be on her just in case for some reason, because she's a squirrel. He could be doing something right here and then, oh, squirrel, and she'll run off. And I'm just scared that she's going to get lost. She's getting better as she gets older. Don't get me wrong. She gets better when she gets older. But, and when I suggested the AirTag, I told him, you have the information at whatever, that's fine for you, can locate her. As long as it's like safety. I mean, same thing, I would do it too. If I was traveling that far away, I would do that also. Just for safety of the child, or a phone or something. Or a tracking device or something on her, just why the traveling part, just for safety. Just because of how squirrel she is. Otherwise, parenting plan, I think I agree to majority of it.
Could I say something?
No, you have an attorney.
So it appears that the Saturday to Monday is working. If my client can just give a thumbs up if those days and times, because that is the first I've heard that they've changed the days and times. But given my client's disability, it is hard for us to connect because we have to have an interpreter present every time. If he can give a thumbs up if the Saturday to Monday is better than the Friday to Sunday.
Yeah.
Okay. So that would be our request then, every weekend from Saturday to Monday. Get the AirTag issue. My client is an adult. Oh, yeah.
Let me address first about the weekends. That I understand at this point, what is being talked about, the court is concerned that it's going to raise issues down the line. So what I would suggest is that the dad have that first, second, and fourth weekend so that mom has one weekend. So she would have the third weekend. And then it would be that Saturday to Monday, as talked about.
And I think that's appropriate. Just right now it might be working and mom can let him have that third weekend as long as she wants, but mom should probably have a weekend sometime in the future with the child should she want it. So I don't think we have an issue with that. I think the issue here is the AirTag. That's the major issue.
All right, so mom had something else she wanted to say. Go ahead.
Oh, you covered it. I just wanted the one weekend a month at least.
So in regard to the AirTag, the court doesn't find it appropriate. I understand why it's being asked, but I'm seeing it being abused. Not that I'm saying mom would do that, but the court agrees with the idea that if dad is responsible to have the child for a weekend, that he should be able to take the child to see his family.
Okay.
So with that, the court would not look to that to be a limitation on the father's time.
And I can prepare those orders and just edit the time and I can get those back to Ms. Makupe for review and if we can set presentation.
Right. So Ms. Makupe, what that means is Ms. Winkles will prepare final orders that reflect what I ruled today and your agreements. Ms. Winkles will send those to you so you can review them. If you agree that it reflects my ruling and your agreement, then you can simply sign off on those papers and they'll be entered with the court as the final documents. If you don't agree that they properly reflect my ruling or what you agreed to, then on September 3, does that work, Ms. Winkles?
That works for me.
September 3 at 9 a.m. The matter will be before me again, and I can make any decisions that are left. Okay.
Okay. I got another question. I did put on there for my family camping trip every year. I mean, like my whole family, big family camping trip every year. He's pretty lenient about it, but I just want to have it in writing that I can have her those 4 days out of the summer for our family camping trip because we have to. I have 7 kids, so we have to. And 4 of them are adults. So we have to see who has off and who, it's really hard to, we plan it a year ahead. We have next year's already planned. That's how hard it is trying to figure it out. If on every year I get her for our family camping trip.
Ms. Winkles?
Yes, Your Honor, we have 2 consecutive weeks of visitation for both parents in the summer, so that they each get a 2-week block or 1 week. I need to talk to mom about this, whether she wants 1 week non-consecutive or 2 weeks non-consecutive or 2 weeks consecutive. Mom can easily choose that. Every summer I can just put mom down as the first choice, dad as the second choice, and that eliminates that problem.
Okay.
Okay. All right. All right. Sounds like that is taken care of. And I believe child support is already taken care of.
He
That's
hasn't
correct.
paid, he hasn't paid in over a year.
Okay, that's a separate issue
Okay,
that
that's
you'll
fine.
have
I
to know.
never
that.
reinstated it, so I'm just wanted to.
Yeah, that should be through the state. They should take care of that.
Yeah.
Okay, so I want everyone to understand that if this is going to be on the docket for presentation, that the interpreter will be scheduled for that. Or Ms. Winkles, if you can arrange it with the court administration.
Yes.
And I want to make sure that it's first on the docket
Understood.
and that nobody is late. If in fact you have an agreed order, then make sure to strike the need for the interpreter.
We will do.
Okay.
Thank you, Your Honor.
All right, thank you. That concludes this matter.
Thank you.
08 Lockwood v. Coleman. We have Ms. Powers. Do we have Devin Lockwood? We have Devin Lockwood. No response. Ms. Powers, have you had any contact or heard from this person?
Mr. Lockwood did drop a statement off to our office, I believe on August 16th. It was also filed with the court. It was not signed and did not contain the provision that it was signed under penalty of perjury, but he did provide that statement in response to our motion.
All right. Well, at this time, I've reviewed everything, so I apologize you've been waiting but I don't know if you have anything to add. I did review the file.
I would just ask the court to enter a temporary parenting plan. We're asking that the father get every other weekend on just day visits. Oh, actually every Saturday, 11 a.m. to 8 p.m. supervised by his girlfriend or Mr. Lockwood's father or stepmom. And then we're asking the court to also appoint a guardian ad litem. And we'd ask that my client's portion be county paid as she's a current TANF recipient. The court did enter child support on July 23rd, so that does not need to be addressed today.
All right, based on the files and record, I will go ahead and adopt the proposed parenting plan. It appeared to be appropriate in the best interest of the child in regard to, and that would include the limitations that were outlined in there. And then the guardian ad litem, who do we have for the next three?
The next three are Karen Lawrence, Twyla Corey, and Heather Hall.
Was that Karen Lawrence or Keith Lawrence? That was number one.
Karen Lawrence.
Karen? I'll go ahead and strike Karen.
So who is that? Who would that leave us? Twyla Corey. Okay, so Twyla Corey will be appointed as the guardian ad litem. And then looking at the income of the father as well, it looks like it would be a county pay. So I'll go ahead and in regard to that, set county pay for the payment. And you said child support order has been entered?
It was entered on July 23rd. The state is involved.
Okay, all right. All right, anything else at this point?
Would the court want to set some review dates or a final GAL report date?
So let's go ahead and just set the standard reviews in the order. The first one mainly to just make sure that dad has, the guardian ad litem has been able to make contact with the dad. So.
Okay, so if we do a compliance out to September 17th. And then I don't know that an interim report is needed here.
No, I don't think there's an interim. So I was looking at 90 and then 120. I think those are the standard numbers.
So if we put it out to December 17th for review of the final GAL.
That sounds appropriate.
And have the report due by December 13th.
Sounds good.
Okay, and then I had one last question. In our amended proposed parenting plan, we asked that visits be supervised by Sky or Mr. Lockwood's family. I should have specified that when we said Mr. Lockwood's family, we meant his father and stepmom. Would it be appropriate for me to add that clarification when I present the temporary parenting plan?
That would be better. It just helps with clarification. That would be good.
Okay, and then in terms of presentation, since Mr. Lockwood's not here, is it appropriate for me to send it over ex parte, or do you want to set a presentation hearing?
So go ahead and send it over ex parte. Just note what docket was on, and just note for his signature that he was not
Excuse
present.
me. I've been here this whole time. I haven't been able to work the Zoom meeting. I've been in the call since it started. I just figured I had to call your. I
Is
had to
this
call someone
Devin
at the courthouse.
Lockwood?
This is, yes. I've been here this whole time. I just could not figure out how to work Zoom. This is only the second time I've used it.
Okay.
Your Honor, this is Taryn. I have been watching.
Taryn, I'm representing you, so you need to not be talking to the court. You can send my office a message.
Okay.
All right. So I'm the one that said you were in and out as far as what I could see, as far as being present. So
I had been in and I was just muted, so I left and joined in to try to get the attention of whoever is. I didn't know that I could control the mute. I thought that it was you guys. I didn't know I could press the *6 or the office receptionist told me how to do it.
So here's the issue at this point. Let me pull it up here, is that you submitted a statement. Let me get to it.
I haven't received a response. I filed the initial plan, so it's really confusing.
Okay,
how I'm
hold
responding
on just a
to
minute, please. Stop for a minute.
Yeah. Yes, sorry. I'm sorry, Your Honor.
Ms. Powers, what was the date that he here? Maybe that's it. I'm not, suddenly I can't find it. I know I read it.
Oh, that he filed his statement?
Mm-hmm.
I believe it was August 16th or August 12th is what I have.
There it is. There it is. All right. So here's the problem in regard to what you filed is that one, it doesn't comply with the local rules. And I understand you're not an attorney, so I probably wouldn't have made that big an issue out of it. But a statement has to be signed under penalty of perjury of laws of the state of Washington. And when it's not considered an admissible statement for me to consider.
Oh, so I didn't put I did the digital signature. I just kind of assumed that would work. So it needs to have like my own written.
Yeah, I don't see any digital signature even on here, but even regardless, there are requirements to make it an admissible declaration. And just so you know, I did read through it, so it isn't that I did just ignored it, but that's a problem on as far as it being an admissible statement. You understand?
I do. Is there a deadline by today that it needs to be in? I believe it said by the 20th. I can sign this and bring it back in if that changes or resubmit it. I don't know if that changes anything.
Honestly, even though I read what you submitted, I don't know if you heard my ruling because I didn't know that you were.
I had switched over in a panic trying to get figured out how I could be added like into the call. So as soon as I heard that I wasn't in the call, that's when I minimized the thing and started making the calls I could to figure out how to fix it.
Okay. So like I said, I read everything. In looking at it, I wouldn't change how I ruled, which is I adopted the proposed parenting plan with the limitations at this time, and a guardian ad litem was appointed. Okay. Do you know what a guardian ad litem is?
Just from what I've been reading on this paperwork.
Okay, guardian ad litem is somebody who makes an investigation and a recommendation to the court as to what the court should do in regard to visitation, limitations, whatever it may be. And so I appointed a lady by the name of Twyla Corey. And I made it, looking at the incomes of you and the mom, I ordered that it would be county pay. So for right now, you really can't argue what's in your statement because it's not an admissible statement. So it wouldn't have been timely. It's not admissible, but I can tell you I wouldn't have changed anything and do it any differently, no matter what. But I don't know if you have anything else you want to add at this point.
I'm just, yeah. So I filed this parenting plan and I'm confused how it's being superseded. I never received a response to my petition. Originally, this is my case number that I filed. So I'm very confused as to why I never received a written response to my petition. And this just seems very backwards.
Okay, so what's happening are called temporary orders. Temporary orders can happen regardless of whether they have responded to the petition yet.
So it's been
Temporary
over
orders
I
are
believe
temporary orders to be followed while the case is happening.
Okay, and so in response to my original petition, will that still be, does any of this go into the light or is it just swept under the rug?
They'll have
'Cause this
to.
was my original case. I'm very
I
confused.
understand you're the petitioner, but that doesn't stop them from filing a motion for temporary orders, which is what they did.
And
Okay.
Your Honor, we
Thank you.
did,
I appreciate the clarification. I have been very confused on the whole
Okay,
process.
and I understand it can be confusing. And just so that you understand, there are a couple of places that you can contact the Cowlitz-Wahkiakum Legal Aid.
Mhm.
They can help you with
Another
some of your
question, I guess.
questions. And the other
This
is,
is gonna,
what's that?
I apologize. This is just pertaining to the immediate, like we've been doing every other weekend and pickups and drop offs. And so now just kind of curious, like what does this go into effect as of today?
So once it's signed by me, then it goes into effect. Once
Okay,
the
well
order is
then,
signed.
I guess. Okay, I just, that works, I guess.
Okay,
Last
so
weekend.
I would
Okay.
suggest if you want to talk to Ms. Powers, that's the attorney for the mom, you can do that. There's nothing stopping you from
Yeah,
doing
I
that.
know. I took the paperwork there. I just didn't assume discussing anything with them was going to help anything.
Okay, so Ms. Powers, did you respond or do the?
thank you. We did file a response to the petition. That was prior to my notice of appearance, but Ms. Coleman filed it on June 6, 2024, and it was served on the father the same day. Proof of service was filed with the court on June 7th. Our response was on the court form response to petition, which looks different than Mr. Lockwood's statement responding to us. So maybe he did not recognize that as a response, but that was the proper response to the petition.
Okay, I see on June 6, 24, there is a response to petition for a parenting plan, residential schedule, and or child support. That is the response to your petition. Okay.
Okay, that was my confusion. For some reason, I only thought that was in regards to only the child support. I didn't realize that it was also in response to the petition.
Yeah, no, that's to the petition.
That was my
Okay.
also confusion. I'm not very versed in law, and I don't have the most knowledge on this stuff, but I'm trying really hard to stay up. And
Okay, well, I gave you a couple of names, Cowlitz-Wahkiakum Legal Aid. They can answer questions for you. Or the Northwest Justice Project might be another place that you can make contact with to help you with some questions. Okay?
And then lastly, Your Honor, since Mr. Lockwood is present, would it be more appropriate to set this for presentation?
I think so.
Can we set it, is your docket, on your docket next Tuesday, the 27th?
That should be fine.
Okay, thank you.
All right, so Mr. Lockwood, what's going to happen is I made my ruling based on the file that's admissible. And so Ms. Powers is going to put together the orders And then they'll be submitted to me for signature next Tuesday. If you agree that it reflects my ruling, and I don't know what you heard or didn't hear, then you can sign off on them and they'll be done and you won't need to be here on Tuesday. But if you don't agree that it's how I.
I have no intentions of signing that. I'm going to be pursuing my original petition until I'm told that it can't.
Okay, that's up to you. So Ms. Powers, I'll just sign off on them next Tuesday.
Okay, thank you.
Thank you. All right, that concludes this docket.